upon you or send some junior forward, and we would like this book to also, because he has referred to,
can you read it?
No, we won't read it now. We let us finish the reference, but these things keep coming up, so we'll want to see the actual book. Please proceed.
This admission tantamounts to violation of constitutional oath of office, which reads as under.
So skip the oath, we can move on.
As such, Article 6 of the Constitution of the Islamic Republic of Pakistan is fully attracted in this case. Next para.
Then there is a statement of Naseem Hassan Shah in Nawai Waqt, Justice Anwar Haq is इंतहाई मुश्किल हालात में अजीम फैसले किए Naseem Hassan Shah.
So where are you referring to these things?
This is 2nd of March 19.
No, this paper book, what is in your hand?
ये मैंने फाइल किया हुआ है.
Okay, it's on the record.
It's on record.
Is there a number to it?
Its number is 57888-2011.
578
CMA 5788 2009 and filed on 31st of December 2011.
2011. Thank you.
Kasuri साहब, आप फॉर्मर चीफ जस्टिस नसीम हसन शाह साहब की स्टेटमेंट पर रिलाई कर रहे हैं?
नहीं, उसने अपना स्टेटमेंट
उन्होंने जो स्टेटमेंट
तारीफ कर रहा है जी सिद्धार्थ,
उन्होंने जो स्टेटमेंट्स दी,
बल्कि
सुन ले
अपनी किताब में लिखा है, अपनी किताब में लिखा है कि चीफ जस्टिस ने कहा हमें चारों जजेस को एक क्वेश्चन दिया कि अपने जजमेंट देखो, जजमेंट को उन्होंने कंपाइल किया.
नहीं, कसूरी साहब, thank you for pointing this out. Attorney General, can you continue reading? Because
paragraph 10.
Yes.
It is important to point out that in Sindh High Court Bar Association versus Federation of Pakistan, PLD 2009, Supreme Court 789, while dealing with the cases of the judges who had taken oath under PCO, the Honorable Supreme Court at page 805 held as under. The judges of the Supreme Court of Pakistan, if any, the Chief Justice of the High Court, if any, and the judges of any of the High Courts, if any, who stood appointed to the said offices prior to 3/11/2007, but who made oath or took oath of their respective offices in disobedience to the order passed by a 7-member bench of the Supreme Court of Pakistan on 3/11/2007 in CMA number 2869 of 2007 and Constitution Petition number 73 of 2007 shall be proceeded against under Article 209 of the Constitution. The Secretary of the Law Division of the Government of Pakistan shall take steps in the matter accordingly. 11. It is also important to mention that Justice Ghulam Safdar Shah, who wrote dissenting judgment in the Supreme Court, was subsequently witch-hunted and ultimately he had to leave the country in a miserable condition. 12. Whether it was legally justified to award capital punishment to Shahid Zulfikar Ali Bhutto in the absence of any evidence worth named and merely on the basis of a totally cooked up and maneuvered story which never stood the test of routine cross-examination. 13. Whether both the Lahore High Court as well as Supreme Court were justified in awarding and maintaining the death sentence to Shahid Zulfikar Ali Bhutto on the basis of a so-called threatened complaint which was blown out of proportion. Whether both the Lahore High Court as well as Supreme Court were justified in becoming a legal precedent sentence to Shahid Zulfikar Ali Bhutto on the basis of a so-called citations, whereas the case of Shahid Zulfikar Ali Bhutto is neither cited nor allowed to be quoted as a legal precedent by the courts of law. It is a judicial murder continuously haunting conscience of independent nation and legal-judicial circles and hierarchies. 15. The unconstitutional and illegal ouster of Shahid Zulfikar Ali Bhutto by a tyrant dictator and subsequent events was the root cause of initiation of an unprecedented criminal prosecution against deposed Prime Minister Shahid Zulfikar Ali Bhutto. It is a matter of record which has been evidenced through the public statements of the cronies of tyrant dictator that he wanted to get rid of Qaeda-e-Awam by all means. The use of judiciary for execution of his malicious designs should not remain part of our legal history, as this country has started treading the path of democracy under an independent and proactive judiciary which has shown its resolve to defeat and foil any attempt to undermine or subvert the Constitution of the Islamic Republic of Pakistan. 16. Was it not legal duty of the regime to conduct an independent and fair judicial inquiry into the incident before starting criminal prosecution against Shahid Zulfikar Ali Bhutto? 17. Was it safe administration of justice to award capital punishment to an accused of conspiracy for murder against whom the essential ingredients of conspiracy were not proved through reliable evidence? 18. Whether justice can be seen to have been done in this case while the appellant was deprived of his right of appeal before the High Court, being tried directly by the High Court. 19. Had he been tried by a sessions court, the trial judge would have been legally bound to follow the case law developed up to the time of trial, whereas the High Court ignored the same altogether. In this case, up to the time of trial and conviction, there was absolutely no precedent of conviction and sentence of capital punishment on the testimony of a prover. Neither in the judicial history of this country, murder trial of an accused was conducted by the High Court in its original jurisdiction, thereby denying the accused a valuable right of appeal before the High Court. The trial in this case was akin to the trial of Bhagat Singh, who too was tried, convicted and sentenced in Lahore on the testimony of a prover. 20. The judgment is per inquirium. According to Black's Law Dictionary, a judicial decision wrongly made is termed as per inquirium. The very fact that three honorable judges, Mr. Justice Ghulam Saftar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, out of 7 gave a dissenting view, whereas 4 handpicked judges acted under the dictates of tyrant dictator, which makes it imperative for the Supreme Court of Pakistan to re-examine the law on the point of approver and criminal conspiracy. 11. 21. It has been ruled by the Honorable Supreme Court of Pakistan in the case of Federation of Pakistan and others versus Mia Muhammad Nawaz Sharif, PLD 2009, Supreme Court 284 as below. Law is not a static object. It has to cope with the modern ideas and concepts and the disputes coming before the court for resolution, as the society with its environmental setup is continuously progressing. Law as well as its remedies are also changing with passage of time. 22. The question of bias needs to be revisited by the Supreme Court of Pakistan in the light of its judgment in the case of Asif Ali Zardari versus the state, PLD 2001, Supreme Court 685. 23. It was a split judgment of 4 versus 3. 4 convicting judges, that is Mr. Justice Sheikh Anwarul Haq, Chief Justice, Mr. Justice Muhammad Akram, Mr. Justice Karam Elai Chauhan, and Mr. Justice Naseem Hassan Shah, and 3 acquitting judges, that is Mr. Justice Ghulam Saftar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, which needs to be revisited, especially after the admission of more than 1 members of the majority view, judges who, as mentioned supra, minced no words in stating that the judgment was given under undue influence exerted by the government of the day. Whereas it is noteworthy to see views expressed by the dissenting members of the bench concerning the evidence of approval, which read as under. As the prosecution case mainly hinges on the evidence of the approver Masood Mahmood, the question arises as to whether he should be believed or not. An overall examination of his evidence has led me to conclude that it is not of the quality on which reliance can be placed. Not only that, it suffers from inherent weaknesses, but also tends to show that he was a man of conscience, which conduct is wholly unnatural in the background of the facts elicited in the evidence. This feature had opened the gate for the argument as to whether the Fikar Bhutto to kill Ahmed Raza Kasuri and his own reaction to it amounted to an agreement within the meaning of Section 120A PPC. However, this question has been resolved in the judgment of my learned brother G. Saftar Shah J, and I need not go into it. The High Court has construed the substantial omissions and improvements in his evidence as one of details or omissions of matters which have been brought on record by the public prosecutor by putting specific questions. In my opinion, these omissions and improvements vitally affect his truthfulness, and therefore in resolving it in favor of the prosecution in High Court, the High Court has given an illusory value to his evidence. If I may say so with respect, this was wholly unjustified. For the benefit of doubt in the evidence must in law go to the accused, as that is the elementary principle of criminal jurisprudence. 24. Accused is entitled to fair trial. Justice rushed is justice crushed. No murder in case in Pakistan right from the independence of Pakistan to date has finally been decided in such a short span of time as in the referred case. This unholy and extraordinary haste in disposal of this case also clearly demonstrates bias. 25. It is enshrined in the Constitution of the Islamic Republic of Pakistan that it is one of the prime jurisdiction of the Supreme Court of Pakistan to do complete justice. Article 187, Clause 1. The assumption of original jurisdiction by the High Court for trial of a criminal case is a question of law which needs to be determined by this court, particularly in the light of universally recognized principle and a fundamental constitutional right in Pakistan pertaining to the due process. 26. At the relevant time, the Evidence Act 1872 was in field and Article 164 of Qanun-e-Shahadat order was not on the statute book. The learned High Court, while conducting the trial in hand, did not take into consideration a material fact that prosecution was not in possession of any evidence of conversation between the approver and the appellant. Surprisingly, this fact was also ignored by the Supreme Court while appraising the evidence in appellate jurisdiction. 27. I may make it very clear that coalition government headed by Pakistan People's Party is neither interested in any type of vengeance against anybody, nor the government believes in revenge. However, unprecedented incident of judicial murder of an international face of Pakistan's twice elected Prime Minister and father of the first Muslim woman Prime Minister and the father-in-law of the President of Pakistan, also twice elected and the founder of the largest democratic political force of the Federation, cannot be left unchecked under the dictates of justice, fair play and history, hence this reference.
Now, can we go to the relevant orders that you were referring to?
My Lord, if my Lords may kindly turn to order dated 21st of April 2011.
Ji.
The President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts
Who was representing the President of Pakistan?
My Lord, it was Mr. Babar Awan at that time.
He's not representing Mr. Farooq.
During the course of proceedings, what happened? He was representing the President
in this case.
No, is he here in the courtroom or no?
His license was cancelled.
He was representing the government at that time. Then his license got suspended.
No, okay.
His license got suspended.
Is he present in court?
No, he's not in court.
Okay.
Now who is representing the president?
The Attorney General.
Attorney General is the
Who
president.
will argue the case?
It is for the government to appoint any counsel.
At that time, the government chose to appoint Mr. Babar Awan as the counsel. And during the course of...
He was not Attorney General.
He was not, man.
Right.
And on 12th of January, while his license was suspended, on 12th of January 2012, while his license was suspended...
No, that's irrelevant.
Another matter...
Okay, now, please proceed. Please proceed. Yeah, I just wanted that clarification. Please proceed.
The facts and the President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts and...
ये जो क्वेश्चन बने ये अब तो कुछ सप्लीमेंट्री रेफरेंस है उस रेफरेंस पे तो क्वेश्चन ऑफ लॉ कोई नहीं है बजाय ये कैसे बने ये क्वेश्चन
कब बने और क्यों बने ये इससे पहले जो orders हुए थे if I may read the order it so appears that the court didn't perhaps made the same observation at that time which my lord has just made and then pursuant to that observation these questions were then forwarded and they were reproduced in this order. The facts and circumstances.
The picture, see, Awan filed this review, this reference, and for 7 days he was addressing this court. People who are friendly to me, they said, Mr. Kusuri, why don't you go there? I said, this can't proceed without me. Let court call me officially. Eventually court called me.